Good afternoon, everyone. Thank you for joining the Judicial Advisory Council's webinar on the judge's role in probation. My name is Arnold Patrick. I am the moderator, and I'm very pleased to have everyone here. We're going to have several videos of judges from around the state, as well as some of the Judicial Advisory Council speaking live and making commentary. We'll be taking questions through the chat pane throughout the webinar, and we will try to get to those questions towards the end of the webinar. We do feel like we have quite a bit of time for questions, so feel free to send your questions in all throughout the videos and the commentary, and we will try to get to them. Really appreciate your attendance, and I'd like to introduce the chair of the Judicial Advisory Council, Judge Rose Guerrero, the district judge out of Hidalgo County.
Thank you, Arnold. Good afternoon, and welcome everybody to our first Judicial Advisory Council Community Supervision webinar, the role of the judge in adult probation. I'd like to give a big shout out to the IT people who have made this possible. We can't get going without them. So Jeff and Art, a big shout out and a big thank you to Arnold Patrick, who is the chair of the Probation Advisory Council, and to Leighton Niles, one of our JAC members. These individuals put so much time, energy into making this program possible. So thank you all very much for your input into making this happen. And thank you to all of those who are attending and watching. Our goal today is to provide you, the general audience, members of the legislative staff attending, advocacy group, and all the audience here, a forum to learn about court practices, operations, and other topics relating to adult probation that will assist in giving very important background information that will guide you in your opinions of things that progress, especially during our upcoming legislative session, and to help to mold and guide us during our future policy discussions relating to adult probation. The Judicial Advisory Council that is putting this program on was statutorily created in 1989 under legislation that created the Texas Department of Criminal Justice. We call it the JAC. It is composed of 12 people, 6 of whom are appointed by the Chief Justice of the Texas Supreme Court, and the other 6 are appointed by the presiding judge of the Texas Court of Criminal Appeals. The JAC members include district court judges, community supervision correction directors, a prosecutor, a defense attorney, and a member of the general public. Each member serves a 6-year term. And Arnold, if you give me an extra moment, I'd like to introduce those members of the JAC that are here with us. I know some will be popping in and out because of their schedules. We have Leighton Niles. He is our JAC member. He is the director of the Tarrant County Community Supervision Corrections Department. Thank you, Leighton, for being here. We also have Judge Becky Palomo, who you will see with a fabulous presentation that was pre-recorded. We also have Judge Angela Tucker from Collin County. We also have Judge Brock Thomas, who's now in the Houston area. And I know that our presiding judge of the Texas Court of Criminal Appeals, Judge Sharon Keller, was unable to join us today. Let me see if there's anyone else that, I did see earlier Judge Gillis, who may be popping in and out. And we also have Carrie Green, the Division Director of the Texas Department of Criminal Justice, Community Justice Assistance Division. I'd like to thank all of you for being here this afternoon to learn about adult probation, how it impacts not only your own individual interests, but the general community of Texas, our citizens, our community. These are individuals in our own backyards. So thank you so much for making the time to be with us today. Thank you, Arnold.
Thank you, Judge. I was going to actually ask you to do that. I'm very glad you did. I also wanted to introduce Judge Molly Westfall from the Tarrant County. She is going to be doing a presentation right after our video presentations. She kindly agreed to do that for us. I had the pleasure of working in Tarrant County and not directly with Judge Westfall, but heard many good things about her. I'm very excited that she's here. So thank you very much. I also wanted to thank, since you've given me the mic for a moment, Arthur Murray and Jeff McShan from Harris County CSCD for helping put this together. I'm very appreciative. So without much further ado, what I'm going to do now is turn it over to those two wonderful gentlemen, and they're going to play some pre-recorded videos from judges, both rural and urban, around the state, addressing different their perspectives and different concepts of the probation role or the judge's role in probation.
Hi, my name is Pat Sebesta, and I preside over the 239th District Court in Brazoria County, Texas. I've had the honor of being the judge for the past 22 years, 4 years as a county court at law judge and 18 years as a district court judge. I've also had the privilege of presiding over our STEP drug court program right here in Brazoria County, Texas, a program I helped start back in 2007. In 2019, I became a member of the Judicial Advisory Council. And prior to that time, from approximately 2011 to 2019, I chaired the Judicial Education Committee for the American Probation and Parole Association, where I had the privilege of facilitating approximately 20 roundtable discussions throughout the United States, where judges and stakeholders were brought together to discuss various issues as it related to community corrections. Issues such as justice reinvestment, procedural fairness, the utilization of risk and needs assessments, the use of evidence-based practice, the opioid epidemic, and many more. The good news is that anytime I left one of those roundtable discussions, my general impression was that in Texas, we were doing a pretty good job. Community correction departments, judges, practitioners are all implementing and applying sound practices as it relates to their counties and their departments. And in Texas, there is a progressive vision toward evidence-based practices. But with that said, I do always believe that we can do a better job. My focus for this video is to talk a little bit about probation from a judge's perspective and to share with you what the common goals and purposes of probation, as well as the daily process involved in community corrections in Texas. Now, we all know in Texas, probation orders are signed by judges on an everyday basis. And we understand that placing a person on probation allows that person who's been found guilty of a crime to remain in the community in lieu of incarceration under various orders of condition of probation supervised by the community corrections officer or the case manager. From that simple definition, I'd like to talk about two things. One, the probation orders, and two, the evolution of the word supervised. From a judge's perspective, the probation order should serve four goals. One, it should hold the person accountable for the crime they committed. Two, it should rehabilitate or habilitate if necessary. Three, it should protect the public. And four, and probably most importantly, it should make our community a better place to live. The terms and conditions of probation are determined by a number of combinations and a number of reasons. It could be the person's criminal history, the kind of case they committed, and if there is habilitation or rehabilitation necessary, then those terms and conditions are determined by either a pre-sentence or post-sentence risk assessment tool. In Texas, we use the TRAS, the Texas Risk Assessment System. And all conditions of probation, whether original or modified later, are always approved by a judge. In all probation orders, we also understand that we have two types of probation conditions, either standard conditions or we have specialized conditions as set forth based on that person's individual needs. A judge's goal is to make sure that every probation order they sign is individualized based on the risk and needs of that individual that they are placing on probation and not just the crime they committed. We as judges understand that each individual is different, and that if probation is going to make a positive impact on that person in our community, then our probation orders have to address those risks and needs of that particular defendant. Can that be difficult? Of course it can, but it is our common goal. And we also understand as judges that as the person moves through their probation, there from time to time, we might need to amend those conditions of probation, amend and add, or amend and remove some of those original conditions. The next thing I want to talk to you about and focus on is the evolution of the word supervised when referring to the term supervised by a probation officer. When I started practicing back in the early 1990s, the community supervision officer's duty was simply to monitor the probationer and to make sure that that individual followed the judge's orders. In other words, the community supervision officer was tasked with simply just checking boxes. Today, with the evolution of evidence-based practices and the utilization of risk and needs assessments, the community supervision officer's duties are now a fundamental aspect of a collaborative justice and the brokerage of services, interventions, and treatment. The community supervision officer is the key player in determining the dosage or amount of services necessary and what, if anything, counseling or treatment an individual needs to be successful. Gone are the days of just checking boxes. In Brazoria County, the community supervision officers work closely on a day-to-day basis with our judges. And if conditions of probation need to be modified or changed, then we have review hearings, we have summons hearings to determine the right services to be provided to that individual. The officers also make recommendations if the original terms and conditions need to be modified or amended. And if a liberty interest is at stake, then the probationer is always represented by counsel. Finally, despite assertions to the contrary, the last thing either the court or the community supervision officer desires is that the individual on probation have their probation revoked. Most technical violations are addressed first by way of built-in progressive responses. And if technical violations persist, then the individual on probation is typically summoned to the court to have to talk to the judge. And only if all efforts fail, then will the state move in and either file a motion to revoke or a motion to adjudicate that individual's probation. And after that, and even then, when they come to the court has three options. The court can do nothing at all, the court can modify the probation, or the court can revoke the probation. And if we're just talking about technical violations, then in my experience, most of the time, either nothing at all is done, an admonition is given to the probationer, or there's an amendment to the probation. The assertion that one technical violation will automatically send that individual to jail or prison, although true, just doesn't happen to the extent that it is an issue. I believe that the biggest issue facing community corrections today is funding, but I'm sure other judges are going to talk about that issue. However, if a department, because of lack of funding, loses staff for supervision of any kind or resources, then caseloads are going to increase, needs are going to not be met, and the ability to supervise is going to be negatively affected. In my experience and belief, if rehabilitation is going to occur somewhere in our criminal justice area or arena in Texas, it's going to be at probation. And not only that, if we just simply look at a simple cost basis analysis and do a comparison, we know that to have a person on probation, it only costs about $2 per day as compared to being incarcerated in jail or prison where it costs $60 a day. Probation today is about determining the risk and needs of individuals, and if treatment is necessary, then having quality treatment providers to help and assist in addressing the needs of the individual. And only by having funding, trained staff, and educated individuals throughout our criminal justice arena and system, only will the goal of making our communities a better life, a better place to live be accomplished. Thank you.
Greetings, I'm Judge Brent Carr, and I'm honored today to have been asked to make a few comments about the relationship between Takumi, the Texas Correctional Office on Offenders with Medical or Mental Impairments, and the various programs that I run. I started a mental health court program in 2003. To date, we've graduated about 570 people. We're very pleased of our recidivism rate, which has remained below 14% during these 17 years. In 2010, I started a veterans program. We've graduated about 380 people. In 2011, we started a program for commercially and sexually exploited persons. Some call it human trafficking. We've graduated about 45. This is a tougher group of people to work with. They're much more higher risk offenders. And then in 2015, I helped develop a program that is presided over by one of our magistrate judges, the Enhanced Mental Health Services docket. Takumi, I'm very proud to say, has their fingerprints on all of these programs. They have been very helpful over the years. And I guess I would like to put it in a little bit of perspective by saying that the mentally ill account for about 60% of people in jail. By that, I mean, according to the Bureau of Justice Statistics, about 60% of people in a county jail, if they were assessed, would show traits of having a mental illness or disorder. That doesn't mean they're unable to function or should not be held liable in many cases for the consequences of their action. I would also like to point out that with regard to seriously mentally ill persons, in the general population, it's about 4%. In the county jail population, it's about 17%, so almost 1 in 5. So in any other area of our society, when that much of the market share possesses similar traits, then it only makes sense that we would gather our resources and deal with them collectively as an economics major to be able to provide services more efficiently, take into account the care necessary in order to properly and appropriately spend taxpayer dollars and achieve meaningful results. So what I know about Takumi's assistance is this. I have called and relied upon them on several occasions. I'm aware that one of their primary purposes is to give individuals involved in the justice system with mental illness a second chance or second opportunities, in many cases to expose them to treatment services with an eye toward diverting them from the criminal justice system. Along with specialized treatment services, Takumi also funds in many jurisdictions specialized probation officers. And across the board, even when dealing with high risk, high need individuals, the recidivism rate reported by their statistics is at about 15%. And when you consider the rearrest rate for individuals entering the justice system is over 50%, that is a whale of a bargain, and taxpayers are certainly getting a bang for their buck. Takumi also has been very instrumental, particularly in our enhanced mental health services docket, in paying for assessments in order to make sure that we are properly dosing and properly sequencing. And if I could go back to the programs that I was mentioning, obviously the mental health court program deals with mental illness, but actually all of the programs that I'm involved with deal with mental illness. The main types that we typically run into, as well as trauma, which in my mind has become kind of the third leg of the treatment stool, a high incidence of substance abuse is also involved with mentally ill people who were attempting to self-medicate. It is a goal of these programs to assemble people with like characteristics, match them up with resources that are developed to address these characteristics, to get an economy of intervention and basically achieve the best results. It is actually my hope that someday we'll be more proactive in the jail, identifying. We do a fair job now of identifying people with mental illness due to the required State Jail Standards Commission screening that is required. But why do we stop there? Why do we not go on to more proactively treat and assign larger groups of people, whether it's a diversion program that results in dismissal and expunction, or a program that simply addresses their criminologic needs, the underlying causes that cause them to be in the justice system, whether it's lack of treatment resources, lack of housing, lack of employment. And that's how you're going to be successful. And Takumi has been a boon in achieving those types of high standard. Takumi has been very innovative in funding programs. Tarrant County had the good fortune to be one of the first programs to have a outpatient competency restoration program, as well as a jail-based competency restoration program. The forensic commitments to the state hospitals have been going up at an alarming rate. We still have a problem there that I would put at crisis proportions, but Takumi has done a masterful job in supporting efforts trying to divert as many people from that situation as possible. And without their intervention and assistance in assessing, providing programming, providing case managers, targeting individuals with mental illness, and being an agency that focuses totally on that part of the population, we would not be making the successes that we are and achieving getting people out of jail with mental illness in a much quicker fashion. I've had the good fortune in my career, as it's beginning to wind down, of being selected to serve as a governor's appointee to the Specialty Court Advisory Council within the Criminal Justice Division. I also serve as a commissioner on the Judicial Commission on Mental Health and as the commission's chair for the Legislative Implementation Committee and the Conference Curriculum Committee. So I have had a rather extensive statewide involvement in mental health issues. And I can say without hesitation that Takumi, usually when I have an issue, is on my very short list of agencies and staff members that I've personally become familiar with to call when an issue presents itself. They've always been very helpful. I look forward to my continued work with them. And again, I think it's vitally important to have an agency that stands apart, that focuses on criminal justice and mental health, as the jail system has become the new criminal health facility. We spend about $300,000 a day to incarcerate about 4,400 people. So in the well over 100 million, I think it's about 130 million a year. And I'm not saying that that we can't make a good case, that some folks certainly do present a danger and should be in confinement, but we have many more people who at the lower end of the public threat to public safety spectrum would benefit by Takumi's continued intervention and assistance. And I look forward to working with them into the future. So again, my name is Judge Brent Carr. I'm very pleased to have the opportunity to speak on behalf of an agency I have come to know and respect. And throughout the duration of my career, I look forward to a continued association and for them to continue to provide the excellent support that they have done in the past. Thank you.
My name is Rex Emerson, and I'm the 198 District Judge. The 198 Judicial District is currently composed of Kerr and Bandera counties. Prior to 2013, the 198th was comprised of 6 rural counties ranging from Kerr to Edwards to McCullough and each county in between. In addition to my 11 years on the bench, I have experience as both a prosecutor and a defense attorney. I will be speaking to you from the perspective of a rural judge. In addition to my own experiences, I've also incorporated the advice from Judge DuBose, Judge Ferguson, Judge Hoffman, and Judge Patillo, which comprises a rural district stretching literally from almost Uvalde to El Paso. Probation is a critical element of the criminal justice system. Ultimately, the goal of all interested parties is to reform and rehabilitate as many persons as possible while protecting the citizens from those who refuse to reform and pose the greatest risk. A rural judicial district faces different challenges from an urban district, and the plea agreement process is integral to our success. In an average year, Kerr County grand juries will return well over 1,000 indictments. Because we're a multi-county general jurisdiction district and have a limited jury pool, the 198th District Court in Kerr County has only about 10 jury trial dates per year. This places a tremendous strain on the system and leads to a plethora of plea bargains. The good news is that because we have a limited pool of defense attorneys and very few prosecutors, they are each intimately familiar with the CSCD personnel and available programs, so they can tailor the plea agreements to the individuals. As a judge, I rely heavily on the attorneys with input from the CSCD departments to negotiate a proper plea agreement with recommendations for programs and assistance. While most citizens look at incarceration as punishment, it is more difficult to complete probation, especially in a rural area. The underfunding and limited resources make it difficult to provide all the programs needed to help probationers be successful. Our CSCD staffs each probationer with specific programs tailored to that individual. It is not uncommon for a probationer to lack basic life skills such as financial management or to need MHDD assistance or substance abuse treatment. The problems and challenges arise when programs such as MHDD, interlock and scram device providers, domestic abuse counseling, and DWI education classes are unavailable in the probationer's county. This frequently results in the probationer having to drive long distances on a work night to attend classes in a larger city, such as San Antonio or San Angelo or even El Paso. Not only does this present a time management challenge, it affects their employment and drains the probationer's limited resources. The key to a rural department's success is a team approach, with greater probationer interaction, more focus on those with needs, and an ability to target limited community resources. Our rural CSCDs will continuously work with the probationers to fulfill their individual needs. Programs are added and subtracted to help the probationer reform his or her behavior to be successful. The greatest hindrance is underfunding and lack of programs. Rural areas used to have grant funding available for GED classes, community service, sex offender counseling, batterers intervention and prevention classes, and substance abuse counseling. Now CSCD departments refer probationers to nonprofit organizations and frequently must rely on the same nonprofits to monitor the probationer's attendance and progress. If NA or AA is not sufficient to help, many rural courts' only option to help is to place probationers in treatment facilities such as court residential treatment centers, substance abuse felony punishment facilities, or intermediate sanction facilities. For instance, we have the Kerr County Specialty Court for substance abuse, but it's seriously underfunded and functions only through the generosity of volunteers, which limits its effectiveness. It is important to note that revocation and incarceration is a tool of last resort. It is not uncommon for probationers to stub their toes once or twice before a significant change occurs. And unless there's a public safety issue, CSCD generally only files motions to revoke as a last resort, either to pressure a defendant to seek the treatment they need or to address consistent, significant noncompliance and behavioral issues. When a person's life is reformed and they successfully complete the program, it's a win-win for all parties concerned. The individual will have the tools to be successful, society will benefit from their input, and the state spends significantly less than the cost of incarceration. I would encourage each of you to better educate yourselves about the limitations and opportunities to improve CSCD. Rural counties need better access to BIP programs, mental health services, quality programs for victim impact panels, and theft intervention, in addition to substance abuse treatment, to name a few. As you work together towards serving the citizens of our state, I would encourage you to view our criminal justice system as a puzzle of tight-fitting, interlocking pieces, wherein if you make a change to one piece, it affects all the rest. Please help the courts better provide the tools to achieve the proper balance of rehabilitation and protection.
Hello, my name is Becky Palomo, and I'm the presiding judge of the 341st District Court, sitting in Laredo, Webb County, Texas. I'm delighted to be here with you today to share my unique perspective earned after 21 years working in the criminal justice system, beginning as a young prosecutor, director of probation, and now a trial judge. Appointed by Texas Supreme Court Chief Justice Nathan Hecht to the Judicial Advisory Council, I thank you for taking the time to be a part of this webinar. In my humble opinion, all of us here today will undoubtedly serve as a catalyst to forming a productive collaboration among those invested in strengthening the criminal justice system in our great state of Texas. As you know, there are many stakeholders within the criminal justice field, including prosecutors, defense attorneys, judges, and probation officers, just to name a few. And of course, we also have those people most impacted, the defendants themselves and their victims, not to mention their respective families. Our criminal justice system involves and affects us all. As professionals, each of us has our own duties and responsibilities that we must adhere to and follow. Yet we all share a common goal. Probation officers and the work that they perform day in and day out across Texas is extremely important to accomplishing our shared goal of achieving justice and realizing TDCJ's mission of providing public safety, promoting positive education and offender behavior, reintegrating offenders into society, and assisting victims of crimes. Having served in almost every capacity as an officer of the court, from the beginning stages of the system towards the final ones, I have been given unique insight and diversity of perspective within the criminal justice system, including the limitations the system creates, as well as the opportunities it offers, the system's strengths and its weaknesses. As a young prosecutor, I took an oath to seek justice and viewed my role to zealously represent the state in the fight against crime and to advocate on behalf of crime victims. And in this pursuit, I had to try my best to discern between who I would recommend to the judge should be placed on probation and who should be locked up. And with the pressure of judicial efficiency and community expectations, my conference meetings with defense attorneys often included the following phrase: "This person committed a felony offense. They're a danger to our community. They must be locked up, and that's what I'll be recommending to the judge or the jury." Remember, we each have a role, and as a prosecutor, it wasn't my duty to consider how incarceration would affect the defendant's future, or how it would likely break up the family, or how the defendant's children now run a greater risk of dropout, teen pregnancy, drug use, prostitution, or how it would label the defendant, decrease his employment opportunities, and diminish her personal growth. None of these factors were in my realm of consideration as a passionate prosecutor. However, it was my duty to understand that incarcerating a nonviolent offender is counterproductive to public safety. A lot has changed since then. Today, we have evolved in a system where prosecutors have an increased confidence in probation and frequently consider alternatives to incarceration in their pleas in the types of cases that before they wouldn't. This is a direct result of understanding the available resources, including intervention programs, diversion programs, specialty caseloads, and specialty courts that promote positive change in offender behavior without incarceration. These options are not equally obtainable in all parts of the state, and you will hear more about these limitations from my colleagues during this webinar. After serving 8 years as an assistant district attorney, I was appointed to serve as the director of the Webb County Community Supervision and Corrections Department. Webb County is located in South Texas at the border to Nuevo Laredo, Mexico. Serving as the director of the Adult Probation Department gave me a different perspective within the same system. My new duties were different, and so were my goals. While still serving justice, my new role actually balanced the protection of the community with the rehabilitation of the individuals we supervised. I came to understand the struggles that probation departments experience and the challenges of working while underfunded and overloaded. In this role, I learned the intricacies of working with the individuals on supervision, gaining new understanding of the true nature and objective of supervision and what exactly success meant with each different population, including the ever-increasing need to address mental health and drug addiction. I gained a greater and more thorough understanding of the impact and the hardships that the system creates, not only on the individuals we supervise, but also on their families and on the community at large. I learned the role of assessments and effective treatment and the true difficulty of achieving positive change under the severe limitations faced by probation departments. Probation in Texas is responsible for half of the criminal justice population, and yet it benefits from only 7% of the funding Texas budgets for criminal justice. Our communities and courts demand more from probation than what their allocated resources allow, and like teachers, often have to do more with less. Many times, I felt discouraged with the weight of the courts and the community's expectations, as I'm sure other directors and probation officers across the state still do every day. I know full well the pressure placed upon probation to succeed in rehabilitating people that have never been habilitated, expected to succeed with decreasing funding and limited resources, expected to succeed with large caseloads which diminishes the quality of officer supervision, expected to succeed with a high staff turnover rate because we lose quality officers to better paying professions. And in this process, expected to succeed at the awesome responsibility of reducing recidivism. This is enormous pressure. And it is a feeling that I will never forget, and I'm always mindful of it now that I'm on the bench. Since 2013, I've been presiding over a general jurisdiction court to include both civil matters and thousands of criminal cases. My current position demands new duties and entails different responsibilities, yet the goal remains the same: to ensure justice. As an extension of the judiciary, the probation departments serve as an invaluable resource by providing reliable information used by judges in considering plea agreements and sentencing options. And judges further depend on probation officers' balanced judgments in reports and recommendations that assist in determining conditions of supervision, degrees of monitoring, and treatment alternatives. As a judge, there are many variables to consider, so many moving parts, some nuances, and some very complex issues to digest before making that final ruling that will have an enduring impact on someone's life. I depend on the probation department to provide me timely, accurate, and complete information designed to assist me in determining the best individualized decision to make on every case. There are 375,000 pending felonies in Texas. As judges, we are given two options for sentencing: probation or prison. Prison costs over $20,000 a year for an individual and has a 3-year rearrest rate of 64%, while probation costs under $700 a year per individual and has a 3-year arrest rate of only 38%. While I have a great deal of authority as a judge, I'm still limited by the system's parameters, and in many instances, limited by the willingness of the individuals I sentence to accept the assistance we try and provide. I now see the forest through the trees much more clearly. I recognize that probation is a critical component of our criminal justice system, yet the bulk of the state resources which are allocated to address the entire criminal justice population goes to those we incarcerate. This is the harsh reality probation departments across Texas must endure, and it is a very important topic that certainly this one single webinar will not resolve. But I am confident that today can serve as the beginning of a platform where we can find common ground and work together to ensure that our state leaders pursue sound practical policies and enact laws that will strengthen probation across Texas and assist and support the people in the trenches to help them perform their work effectively and efficiently. When I wear my robe, I have the power of the pen, but I need your help. I ask you to commit to being as informed as possible about each role within the system, to welcome a diversity of perspectives to the table before making decisions that affect everyone, not just the offender. I am asked to testify on proposed legislation that, while well-intentioned, does not consider the direct and indirect impact on our jobs in and out of the courtroom. I invite you to ask questions, learn the practical consequences, challenges, and impact on the system as a whole. A solution might at first glance be the result of collective efforts. However, the collaboration must include the voices of every role within the process. An informed judge is less likely to oppose a proposed mandate if lawmakers welcome insight into its practical effect upon every stakeholder and jurist. Communication is key and the most effective opportunity for public servants to achieve our shared goals of ensuring public safety. In closing, from my perspective, I have come to realize that granting community supervision is more effective and efficient. And I don't disagree with the data and practical realities that must limit any effort to increase incarceration when money and space is scarce, particularly in our current environment. Please reach out to me if I can be of service to you in any way, or if you have any resources to share with me that will help me become a better jurist. Thank you for everything you do to make Texas safer.
I want to take a moment to thank the judges that took the time to put the videos together. It was very impressive to get such a wide variety from across the state, both rural and urban judges to present their views and commentary on this subject. Next up, we have Judge Molly Westfall, who is a district judge out of Tarrant County, and she's going to make her commentary live because she's just that brave. So thank you so much.
Actually, thanks for the props, but we had some COVID turn up in the family, and so I was supposed to record something, and it turned out that I was not able to record my my speech in advance. So I'm trying to get my screen sharing going here because I have a PowerPoint that I want to share with you guys about revocations. One of the, I think maybe, I have too many windows open. Surprise. One of the issues that I had testified last session about was the revocation issue. And there was quite a bit of discussion about how to best handle revocations and how to manage judges' roles. Here we go. So I will go ahead and get us through here, get us started. Again, my name is Molly Westfall. I'm judge of the 371st District Court. I'm coming up on my 25th year in the criminal justice system. I spent 11 years as a prosecutor, and I'm finishing my 14th year on the bench as the judge of the 371st District Court. A little bit of background, because I think that we've heard from a number of judges across the spectrum of different types of counties in Texas, because you can't generalize about district or the criminal justice system. It's different in every county according to the size, the resources. A little bit about Tarrant County. Judge Brent Carr is also from Tarrant County. The population of Tarrant County is 2 million people. So we have 10 felony criminal courts to handle all of the felonies that come through Tarrant County in a year. Generally, recently, we've had about 20,000 new felony cases, independent of revocations, which are not counted as criminal cases. 20,000 new felony criminal cases filed each year. We're disposing about 17 or 18,000, of course, mostly by plea bargain. That would be pre-COVID. This year is definitely an outlier. Each court in a normal year has about 15 to 25 jury trials in Tarrant County, each felony criminal court. And generally those cases last about a week. 10,000 people are on felony probation in Tarrant County. So we have about 1,000 people to supervise per judge. Now, some of the other duties that judges have besides the big ones, which everyone thinks of, is handling the trials. We take the plea bargain, so we have to have dockets in which to do that. We hear motions to suppress, open pleas of guilty, other kinds of evidentiary hearings. We also hear writs, both people who are detained pre-trial and people who are post-conviction and challenging their convictions. We handle those if they came out of our court. We handle the supervising and hiring of our magistrates. Each of us have to impanel a grand jury every year. And I can tell you right now, that is very tricky. All of the felony judges sit on the juvenile board, and we manage the appointed counsel wheel for indigent defense, the attorneys who apply, and we consider whether there are problems with attorneys who are on those wheels or whether they want to get an additional level of appointments. We hear expunctions in our courts and forfeitures, both asset forfeitures and bond forfeitures. All mental health commitments for anyone who's in my court who comes up incompetent. I have to appoint an expert, get the report back, and to make a decision as to what needs to happen to that person. I have to pay every single appointed attorney who does work in my court on every case, and personally, investigators and experts as well. 5 of the 10 felony courts also have diversion or specialty court duties that they've volunteered to undertake. I have one, and we have a number of them I used to have 2, but I gave one away, and I have one now, and we have a number of judges who are handling generally populations of people with addiction issues that they're following up on. All warrants to search cell phones, social media, computers, or cell phone records must go to a district judge. So I have detectives coming to my court, to my house to get those signed because me or another 9 people in Tarrant County have to sign those. So really the bottom line is our time is in high demand, and so we have to ration it as district judges in a large urban county. This is kind of the way probation happens in Tarrant County. It's almost exclusively negotiated by the assistant district attorneys through plea bargains. About 99% of our cases are disposed by plea bargain. We have 17 or 18,000 disposed a year, and we only have the capacity for a pittance number of jury trials. We accept the plea. From that point forward, that probationer is in the hands of community supervision. As judges in Tarrant County, we rely completely on the TRAS, the assessment that's in place, to set all the conditions of probation in the case, unless there's something that's negotiated, like no contact with the injured party or a restitution amount. Other than that, the TRAS sets all of the conditions. Then the probationer is referred out to a field unit because we have a number of units across the county that see people in different parts of the county. And if the person's successful, we'll never see them again. If a field officer decides to use progressive sanctions or to amend the probation for an additional treatment program, if the probationer is agreeable, then that amendment is just sent in an envelope from their office through interoffice mail down to my office where I sign it. I still don't even see the probationer unless there's some issue that they have with agreeing to their amendment. When an officer recommends revocation, that recommendation is reviewed by the court officer, but it still doesn't make it to my desk. It's forwarded to the DA's office because the DA's office is the prosecuting authority. So they decide whether they want to go forward on the revocation. So they file the petition. Then when a petition is filed, I will appoint an attorney for the probationer if they're indigent, which usually they are. The state and the defense then negotiate what they want to see as a resolution in the case. That could be a variety of things. sometimes most of the time, 99% of the petitions that are filed, I still have not talked to the probationer or talked to anyone about what's going on. Everybody has agreed. They just bring it to me to bless. Either somebody is they're getting revoked, or they're getting reinstated, or they're getting reinstated with a recommendation for treatment. So occasionally, of course, I do hear revocations, either because generally because the defense is wanting reinstatement, and only I will do it because the state won't agree to it in certain circumstances, or if the state really wants somebody to get a really high number, which is very rare, but occasionally does happen. They just can't agree on the number that everyone can live with. So I grabbed the 60 days worth of data of revocations. As soon as Leighton asked me to give this talk, I thought, I wonder what is happening with my agreed revocations that, I never see. I don't have any real input into what's going on. Everybody has agreed and I just take the plea. So I grabbed a 60-day snapshot of all the cases revoked. It's not probably the most representative sample because of COVID, but revocations are still going forward in my court through agreement. There were 30 people revoked through plea bargain in September and October. 15 had new offenses. 4 had absconded 3 to 6 months. One of those 4 never even came to intake. She just decided not to do probation at all after she had accepted it. 2 declined the treatment that they were offered after they absconded, and 1 also had a new offense. 5 absconded 9 to 12 months. 2 also had absconded treatment, and 1 had a new offense. And then 1 had absconded for 6 years. 3 of the people who were revoked had already been revoked in other counties, so we were just echoing that revocation in Tarrant County. 4 had failed treatment, and they were offered additional treatment in lieu of revocation. They just didn't want to go to additional treatment. I noticed from reading the chronos, 1 had, the probation officers noted, I called him to offer him contract residential. He said, I'm done with probation. I'm already working with a lawyer to get a revocation. 1 had absconded probation and addiction treatment for 5 months. She was arrested on a new assault. She had serious mental health issues. We went to a hearing, and during the hearing, I said, won't you please consider SafeP, special needs for your mental health issues? And she thought about it with her attorney, declined, and then accepted the state's plea bargain of 2 years. 1 was unsuccessfully discharged from sex offender treatment, and 1 was unsuccessfully discharged from 3 different treatment programs, including Brent Carr's RISE program. 1 relapsed and absconded from treatment and ended up getting 30 days in the Tarrant County Jail instead of going back through treatment. So of the revocations, 30 revocations that I looked at, 13 resulted in the minimum sentence in the case. 7 got 1 to 2 months of state jail or 1 year TDC above the minimum sentence that they could receive. 6 got 1244A reductions to Tarrant County Jail instead of going to state jail. 2 were misdemeanors, and 2 received substantially larger sentences than the minimum. 1 was 5 out of 20 instead of 2 out of 20. 1 got 9 out of 10, but he had 8 new offenses. So in summary, the revocations during the snapshot that I took were largely driven by new offenses, absconding, and refusing treatment. And the probationers know that they're likely to get minimum sentences because the DAs in most cases don't want to go to the trouble of having a hearing. They want the case to work out because of the volume of cases that we have. They have to also ration their time and attention to the cases that they feel the most serious about and work out the rest. So the rest are, most of them are worked out in a minimum on an agreed revocation. And the probationer, that's what they want because they just want to be done. Additional treatment is being offered in a progressive way, but rejected at revocation because they want to be done. Probationers who have been given a chance at probation after prior convictions are likely to struggle. Over 50% of the people who were in revocation proceedings during this 60-day period had prior criminal history. And we're always glad to see prosecutors or whoever putting people on probation and giving them a second chance after they have convictions. But those people are more likely to fail because they've failed before, and failure is not as difficult for them. So let me stop my share. In summary, looking at my revocations, that's what I see in just a random snapshot of what is going on in Tarrant County. And the reason why I have to look at it is because most of it is going on outside of my view as a district judge. I'm not driving the revocations. The prosecution and the defense and the probationer are making that decision without much input from me in most scenarios. So that is my presentation.
Thank you so very much, Judge Westfall. We really appreciate you doing that. And thank you for sharing your 60-day snapshot. I thought that was quite telling. And I already have a feeling that I'm going to be asked to do something similar for several of the courts in my jurisdiction, but I think it's a fantastic idea. So thank you for sharing that, and thank you for participating. So next up, I'm going to ask the chair of the Judicial Advisory Council to, if she has any comments, which I believe she does, and then I'll go through and each of the panel members and ask them if they have comments. I just want to remind the participants that all throughout this webinar, you can enter your questions in the chat frame. I've received a number of questions so far, but I just want to encourage y'all, if you have questions, even if it's specific to one of the panelists' commentary, please put them in there so that we can try to get to them after the commentary is done. So with that, Judge Rose, Reyna, would you please do your commentary?
Thank you, Arnold. For those of you who don't know me, my name is Rose Guerra Reyna. I'm the judge of the 206th District Court from Hidalgo County, Texas. And we live on the border. Our county sits on the border, which brings unique perspective to some of the different types of situations we see. I've been on the bench. I'm in my 22nd year. The learning curve has been extraordinary, to say the least. And I've been on the JAC, the Judicial Advisory Council, for 14 years now. I'd like to visit with you just very briefly about modifications. And in that, I ask you to keep in mind what each of the presenters have already said so that you can place it a little bit more into context. We heard from my colleagues what the purpose and goal of probation is, the different programs and resources that may be available to probation departments, the impact of resources and funding, how that plays a part in how a probationer can be supervised, and challenges for some of the rural communities. Some of my comments may be very basic to those of you in the probation field, so please bear with me because we did invite members of the legislature, their staff members, special interest groups, and others who may not be familiar with some of the alphabet soup acronyms that we use and some basic information. So first of all, I'd like to give you a friendly reminder that for felony probation, generally speaking, there is a limit to the number of years a defendant can be placed on probation, no more than 10 years. That includes any increases over the period of a lesser period of probation. The limitation in a misdemeanor case is 2 years. So let's visit a little bit about the who, how, why, what about modifications. Who can modify the conditions of probation? You heard Judge Westfall talk about her procedure and how the modifications work. Quite often they're administratively done and they're handled just through paperwork. However, sometimes they are the result of a contested hearing with evidence presented. Generally speaking, there are some larger jurisdictions that have the resources where they have hired, based on an appointment of the district court judges in their community and county, to have a magistrate address those type of issues instead of the district court judge who heard the underlying case. We do not have those resources in our county, so each district court judge or county court at law judge hears their own motions to modify. How can probation be modified? Well, you can obviously delete conditions that have been imposed. You can add conditions that have been imposed. You can extend conditions by a period of time. For example, you could have ordered someone to submit to random UAs for a period of 2 out of their 4 years of probation. But because of things that have gone on in their life or based on how they have been conducting themselves, that may be extended for an extra year, an extra 6 months, depending on the circumstances. They can also shorten different conditions. Why would someone even modify conditions of probation? Well, that's a whole nother day topic, but generally speaking, the why. Now, if you think about the fact that we have defendants on probation for years, hypothetically, let's say I have a defendant on probation for a period of 8 years. I guarantee you that person's life from the first year he was on probation until his 7th year of probation is going to be a very different picture. It may be better, it may be worse. So those are countless reasons why probation would be modified. Think about your own lives. 8 years ago, where were you? What was your life circumstance? Did you just have a child who had a horrific situation that you had to deal with? Did you undergo a separation or a divorce? Did you have a physical disability or a loved one pass away? Not that any of those are excuses for people to commit offenses and be placed on probation, but that's life. Life happens. And these type of problems that result in criminal offenses, they don't discriminate. I know every judge in this program who is speaking can agree with me that they have people on probation who were rich, poor, Anglo, Hispanic, Black. It covers the gamut. Problems do not discriminate. So that's one of the very basic overviews of why a judge would end up modifying conditions of probation. What kind of conditions could be modified? Well, if you're not familiar with the probation system and the actual criminal justice system, it would be mind-boggling to actually put a list together of all the different types of conditions that can be imposed depending on the offense, depending on the defendant, depending on the results of assessments, which we rely on heavily. They're evidence-based, validated assessments that we utilize in order to make our decisions, whether to modify conditions, whether even to place someone on probation. I'm very fortunate because in our county, in my court, I have the ability and resources to order these assessments before a defendant is placed on probation. So let's say hypothetically, it might be a burglary of a habitation offense. Well, you think, well, why are we even talking about substance abuse treatment? It was a burglary of a hab. Well, lo and behold, the assessment is very insightful and provides a lot of information and may reveal why the individual is engaging in that type of conduct, so that it necessitates some type of substance abuse treatment, perhaps inpatient, perhaps outpatient. So I started to come up with a list of different types of conditions based on different type of offenses. And I got tired, to be truthful, because we have people on probation for every type of offense you can imagine. Sex offenders, DWI, manslaughter, theft, burglary of a habitation, assault, criminal negligence, homicide. It just runs the gamut. And you may be a bit offended to think, how can a judge put a sex offender on probation? Well, we look at the defendant, we look at the offense, we look at a whole lot of information in order to make those determinations. And along those lines, there are certain type of programs available for the different type of offenders. And probation has done an extraordinary job of focusing on specialized units. the sex offender unit, a mental health unit, because there are so many major components involved in a defendant's life that impacts their choices, their negative choices. And probation's goal is to help them not make those choices again and to correct the wrongful choices that they've made in the past. So what are some of the kind of conditions that could be modified? And these are just general conditions I'm throwing out there for those, excuse me, not real familiar with the actual courtroom setting. A drug patch, random urinalysis, substance abuse treatment, electronic monitoring, house arrest, curfew, community supervision, community service restitution, ignition interlocks, paying back restitution to a victim, mental impairment services, mental health court services, individual counseling, group counseling. We may also find that over a number of years, defendants are doing extraordinarily well, which, believe it or not, that does happen. And it is with great pleasure that after I get recommendations from a probation officer that a defendant report less often because they are doing so well. Or in the opposite situation, they may need to report more because of different situations, which we have seen in the last 9 months with COVID, a different style of reporting. A year ago, we were all reporting in person to the probation department if you were a defendant. Well, then COVID hit. So being as wonderfully adaptive as the community supervision departments were, they integrated the technology and they made available means so that they could continue to do what the law requires them to do in their capacity as probation officers in a safe environment, safe for the probation officers and safe for the defendants. So perhaps a defendant will report by mail. Perhaps they will report electronically. And even post-COVID, I've had people ask me, well, what are your thoughts about all this electronic stuff? I'm all for it. It seems to work under certain circumstances. So those are just a handful of, oh, and I forgot to mention, there could also be certain type of counseling programs with the use of lie detectors, which some sex offender treatment individuals utilize in order to assist as the probation officer supervises those type of offenders. We also have victim impact programs available so that perhaps a defendant in a felony DWI case may have the opportunity to hear from a family member of someone who lost a loved one to a drunk driver. So the resources are countless as far as different programs are concerned, but they all cost money. And someone had mentioned previously, well, what about the financial impact to probation? Well, needless to say, as someone mentioned, I think it was Judge Palomo mentioned, just like education, a lot of work needs to get done and there's never enough resources. And I say kudos to our probation officers because they do a phenomenal amount of work with such little resources. And I know we're hitting a big budget crunch with the session coming up because of the lack of money that came in based on numbers that the state comptroller has provided. But to reduce the budget for probation when their goal and their lifelong purpose has been to ensure a safe community for you and me, our loved ones, and everyone in the state of Texas, would do such a disservice. We rely on probation so much to make these decisions, whether to modify, to increase, to delete, to lengthen or shorten probation periods. I rely so much on my probation officer because they are the ones that have seen the defendant during the period of time they've been on probation. They know so much more about that defendant than I will ever know. There is an exception, however. I have the privilege and have had for a number of years the privilege of overseeing our reentry court program. That program is a program where defendants who have completed a 6-month residential treatment facility in Hidalgo County run by our local probation department, when they complete that 6-month period, they start reporting to me as part of a reentry court program. Research indicates that individuals who complete a residential type of treatment will usually reoffend or relapse immediately after the program is completed, because they were in a residential treatment. They didn't have to deal with the real world. Now they come out into the real world. That's the test. So we have been able to, with a very shoestring budget that we have, been able to create this reentry court program so that we staff cases with a team that involves probation officers, counselors, a public defender, the prosecutor, the court, and supervisors from probation. And when we actually staff those cases, I know everything about those defendants, what's been going on in their lives. I found out that their wife had a baby. I find out that someone lost the wife and he's raising 2 teenage children, and the challenges that that imposes on them, and then having to deal with that with the situation that they've already had to incur. Being in Hidalgo County, as most of you may not know, we are one of the counties with the highest indigent population. So we may have these resources, but it's extremely difficult to tell an individual who is supporting a family on a minimum wage, and I'm sure this is across the state, not just Hidalgo County, to have certain type of conditions imposed upon them, which, you know, how much does an ignition interlock device cost? We do want to keep our community safe on those DWI cases. There are certain pieces of legislation that require certain minimum conditions on certain type of offenses. And then there's others that the court has a discretion, but we rely on the assessments. We rely on the information from the probation department because they are the ones that have the information, the knowledge to know what is going on in that individual's life. Are we going to revoke someone because they tested dirty one time? I know I won't, and I can't imagine any of my colleagues would either. What happens is the probation officers delve into the probationer. What's going on? Oh, you just lost your mother from COVID, and whatever the situation, those are explanations, not justifications for their choices, but they are explanations. So with that information, the probation office can determine what is the best way to continue to guide this probationer over their period of probation in order to continue to rehabilitate them despite, and I love the term, I think Judge Carr mentioned, the stubbing the toe, because occasionally a probationer will stub their toe. Does that mean they belong in prison? Absolutely not. It just means that we deal with that stubbed toe and move forward and continue to move forward. So I love probation. I love my job and I'm extremely passionate. I could go on for a whole week, but I'm going to go ahead and cut my comments at this point. In closing, I just want to reiterate how important it is that we have a strong, intelligent, and well-financed probation department, because we as judges can only make decisions, the best decisions possible, based on the best information possible. And with the system we have, that information is coming from probation. The assessments that they do that enlighten us as far as what direction to focus on during their period of probation. So I thank you very much. I welcome any stakeholders or special interest groups. If you have any questions, feel free to reach out to me for additional information or comments. You can find me. My name is Rose Reina, 206th District Court from Hidalgo County, Texas. Thank you, Arno, for letting me share a few moments. Thank you.
Thank you, Judge. I appreciate your comments. And again, that's the chair of the Judicial Advisory Council, Judge Rose Guerra-Arena. I'd like to just quickly introduce Judge Becky Palomo from the vice chair of the Judicial Advisory Council. I know she already did a video presentation, and I'm not going to put her on the spot, but I did want to mention that she is on the panel, and we may benefit from her insight on some of the questions that I've received a number of. I'll remind you to enter your questions in the either Q&A or the chat panel, either one. We're getting them both. Next, I'd like to introduce Judge Angela Tucker, a district judge out of Collin County, and ask her if she has any comments she'd like to share.
Hello, everyone. My name is Angela Tucker. I am a district judge in Collin County, the 199th District Court. I have been on the bench since 2012, but I've been involved in the criminal justice system for about 25 years. I started as a prosecutor, and then I was a defense attorney on the bench. And so I think that gives me unique perspective as it relates to working with probation, and very, very important. Judge Westfall gave you an overview of kind of everything that district judges have to do, everything judges do, the many hats that we wear. Judge Reina gave you very specific details on the resources we have available, how those things work as it relates to probation. So I just wanted to talk for a minute on kind of what judges deal with as it relates to probation on a daily basis. So not everything that we do, but everything we do as it relates to probation. And I think after listening to Judge Westfall and then hearing this list, you're going to see just how busy your Texas judges are and just how much we rely on our probation departments. So I divided my list into in court and out of court, because I think you've heard from the judges, even though we're on the bench a lot, there is so many other things that go on behind the scenes that we're doing outside of court. So my in-court list, I started with agreed pleas. So you've heard many judges talk about that. So again, that's when the prosecutor and the defense attorney reach an agreement and they present that agreement to the court. And even though it seems like we're just kind of approving it and moving on, the judge is still looking at those terms and conditions of probation. Does this really fit this case? I know one of my cases, for example, the prosecutor listed a cognitive thinking program and moral recognition therapy. Those two things are going to address the same thing. So there's no reason for me to order both of them. So sometimes judges have to question that. I had a homeless man that had been homeless forever. He had mental illness. One of the terms and conditions of probation was a defensive driving course. He doesn't have a car. He lives in a homeless shelter, has lived there for years. Why in the world do we need a defensive driving course? You know, and so sometimes as judges, we do have to ask those questions, because I guarantee you, when it gets to probation, the probation officer is asking these questions because they're the ones responsible for helping these people get to these resources, sign up for these things. And they often question, is this really necessary? So judges are reviewing those. If you don't know, on a felony case, a person can also go to county jail for up to 180 days. So sometimes there's terms and conditions of probation which relate to jail time, even though the person is on probation. So sometimes the judge is helping to schedule that. You know, is the person permitted to do it on weekends? Do they have to do it all at once? All those different things are things that we look at even on an agreed plea, which some people think is just kind of moving it down the line. The second in court proceeding that we have that relates to probation is an open plea. So an open plea is the person saying, yes, I'm guilty. They're pleading guilty, but they don't have the benefit of a plea bargain agreement or a deal. They're going open to the judge, and the judge is going to decide what the punishment is. And so I think you've heard now from several of the judges, just kind of nuts and bolts. We can use all the fancy language, but just breaking it down on layman's terms, the judge is deciding probation or prison. That's just getting down to brass tacks. That's the decision that we're having to make. So we're getting all of that information, all the evidence that we're hearing, and then that's the decision that we're making. Then, of course, we have trials. Trial before the court, again, the judge is deciding the punishment. And then some of you may not know that even on a jury trial, so when a jury is deciding guilt or innocence, the defendant decides before the trial begins whether the judge will assess punishment or the jury will assess punishment if the person is found guilty. So we can have a jury trial and then the judge still has to assess punishment. Again, deciding probation or prison. The next area that we spend a lot of time are probation revocation hearings. And I think our judges have covered this pretty clearly. We have to decide whether to continue that person on probation, amend the conditions of probation, or revoke that person and they go to prison. So again, the judges are receiving evidence, they're listening to testimony, they're making those decisions on probation revocations when there have been violations. Another court proceeding related to probation, motions for early release. So if a person's on probation, they think they've, done all their terms and conditions, they've benefited, they've learned from it, they'll file a motion for early release sometimes and say, hey, judge, look at my file, listen to my probation officer's recommendation, and I want you to let me off probation early. So in that situation, the judge is either granting that motion or denying that motion, saying, I think you need to stay on longer, or there's some additional things that you need to do. And we rely heavily on our probation officers to let us know, how is this person actually doing on probation? We talked about stubbing the toe. Well, how many times have they stubbed the toe? How recent was that, as it relates to motions for early release? The next proceeding, sanction hearings. So I think Judge Reyna covered this really well, that sometimes people think, if a person messes up one time, that the judge is shipping them off to TDC. And that is not accurate. Probation works really, really hard. And I didn't realize how hard they work until I actually was on the bench. Because sometimes I would get so many of these hearings and amended orders. I was like, at what point do we get the revo, right? And so I sat down with my probation department and they explained, hey, Judge, we have progressive sanction guidelines. So like Judge Reyna talked about, someone tests positive for marijuana while they're on probation, the probation officer may sanction them 3 days in jail, or 5 days in jail, depending on what the violation is, 7 days in jail, or they may have them do another assessment. Again, trying to prevent the revocation, but also trying to get compliance. And so we have a lot of sanction hearings, particularly if the individual disagrees. So the probation officer says, I want you to spend a weekend in jail. The probationer doesn't feel like that's warranted. As Judge Reyna pointed out, I had a situation, my mom died and that's why I didn't report, or there was something going on, and they want to come in and share that information or testify to that information for me to take into consideration whether or not the sanction should be given. And then of course, in our county, if there's any loss of liberty. So if the person is going to go to jail, if the person is going to go to a lockdown treatment facility, we always allow them to come in and have that sanction hearing. So we have those as well, which takes court time. I think Judge Carr spoke about drug court, and I'm on the Specialty Courts Advisory Council with him. We do a lot of work in Texas surrounding drug courts, and it takes a lot of court time, but it also takes a lot of the probation officers' time and money and resources, because you are meeting with those individuals much more frequently. You are spending a lot more time with individuals in drug court, much more time than you do with a regular person on probation that you might see once a month. With drug court, you may see them once a week, you may see them twice a week. So that really varies. The next is a compliance docket. And I got this idea actually from Judge Paloma, who is wonderful. And I use this with my youthful offenders. So we may have 18-year-old, a 19-year-old, because as you know, in Texas, at 17, you enter the adult criminal justice system. We also know at 17, you do not have an adult brain. So 17-year-olds and 18-year-olds sometimes do things as youthful offenders that we really have to kind of try to help them along more. So Judge Paloma introduced me to the compliance docket for youthful offenders. And so what happens is if a probation officer identifies this is a young person that is having trouble kind of figuring out how this is supposed to go, or they have some other barriers, we bring them in on a compliance docket. And I talk to them about what is the barrier to success. You know, do they not have transportation, or they don't have a phone, they don't have a job, they're relying on their parents, you know, I'm still in school, whatever the situation is. And then we try to help them alleviate that barrier to success on probation. And so again, I rely on my probation officers to bring those individuals to me. They bring them to my attention, and then we kind of monitor them. If there's other community resources they need, we help in that regard. The other thing I wanted to point out is my court is a general jurisdiction court as well. So my court hears civil, criminal, family, CPS, and then I have a drug court. And I think a lot of times we only think of probation officers in the context of a criminal case. However, having a general jurisdiction docket, I may see a probation officer have to come into my court and testify on a family law case. You know, if it's a nasty divorce, there's subpoena and probation records. They want the probation officer to come in and say, you know, the husband, you know, is a drunk and he never shows up, all these different things. So sometimes our probation officers are pulled into non-criminal cases, or CPS cases, because a lot of times those of us that work in the system know that the systems cross. You may have a protective order and a divorce, you know, criminal case and a family law case. And so our probation officers are not limited just to the criminal justice system. So I did want to point that out briefly. Out of court, I think our judges have already covered this pretty well. We do a lot of signing, whether it's electronic. In the old days, it was the pen, but now we are signing. So probation officer orders, amended conditions, we sign and set bonds on revos. So for those of you that aren't used to the criminal justice system, when a revocation goes through the system, as Judge Westfall pointed out, a warrant goes out and we have to set a bond for that individual. If they're on deferred, if they're on regular probation, then it's up to our discretion, but we have to set bonds. And then also part of our out of court time is spent meeting with our chiefs, meeting with our probation officers, getting updates, getting our questions answered. A lot of times our chief is really good in a very nice way of saying, hey, judges, you're screwing this up. You know, you're ordering things that we don't have funding for, or you made up this program. We don't even have this program. What's on the probation orders? And so he very gently comes into our meetings to let us know when we have gotten off track, and he helps us to get on track and stay on track. So that relationship is significant and it is important. And as the judges have said, we rely heavily on the training, the experience, the knowledge of our probation department, because as Judge Westfall pointed out, as judges, we are constantly changing hats 1 minute to the next. And so we have a lot going on. So it is critical to have a strong probation department with a strong leader that can help us and assist us. The last thing I wanted to say is, as we're going through this process, the judges have highlighted so many important things that affect this system. One thing that I wanted to say in summary is judicial discretion. Judicial discretion is key. It's significant because out of all the things that you've heard on my list, you heard from Judge Reyna, you heard from Judge Westfall, we have a lot of discretion. We are making a lot of decisions, but it is really hard when our job is to dispense justice when our hands are kind of tied behind our back sometimes, or we're limited on what our options are. And so it's important, I believe, when we are making changes to statutes and policies, funding, that we take all these things into consideration because they all work in concert. You cannot cut one thing and expect it to bloom on the other side. It all works together. Everything has to continue to flow. And so even down to name changes. So for example, if I was listening earlier when we started this, and I always have to remind myself to say community supervision, because for those of us that have been in the system for a very long time, it's probation. And if you listen to all the presenters today, we still call it probation because that's our term of art. Same way when they were changing, Section 3G, that is a term of art. So my plea to you would be to please consider the stakeholders when you are making changes, whether it's in a statute, a policy, or a name change, because all of these things are significant and important in the way our system works. So hats off to our judges. I am honored to be a judge in this state. I've been so proud of the way we have responded to this pandemic. And I want to say hats off to our probation departments who have always done more with less all the time. Probation departments have been the lifeline during this pandemic. And why do I say that? Our jails were full because there was no movement. We couldn't transfer to Dallas. Dallas couldn't transfer to us. We couldn't go to Tarrant. Everybody was in a standstill as it related to county jails. TDC units were shut down because of the pandemic. They were on lockdown. COVID was rampant. No one was moving. So the part of the criminal justice system, though, that continued were your judges that hopped on these boxes for Zoom with our million hours that we've logged in, and our CSCD departments that very, very quickly adapted to the technology and figured out a way to still get these people to report and to do their jobs and to keep our communities safe. So I think that they have proven time after time that they are a significant part of our criminal justice system, and the system simply will not work without them, and they cannot work without proper funding and resources. Thank you.
Thank you, Judge Tucker. I appreciate that, and I appreciate the kind words you said about probation. Next up, I would like to introduce Judge George Gillis. He's a district judge out of Midland County. I'm hoping that Judge Gillis.
There we go.
There we are.
Okay.
Judge.
Thank you very much. I can tell everyone that these are hard acts to follow due to the depth that they have covered of what probation does, what judges do. And this has been a difficult time. I'm judge of the 142nd District Court in Midland, Texas, out here in West Texas. It's a court of general jurisdiction. I do not handle much family law, and other courts begin to handle juvenile law. I handle civil cases and criminal cases as well, as many of the other judges do. And sometimes that puts a strain on the court, depending upon who is sometimes, clamoring the loudest to, obtain part of our time. But it is something that we have all learned to juggle over time. I'm in my 28th year of being on the bench. And I'd like to answer some of the questions that have shown up on the chat, because I think the other judges have given us a good overview of how the system begins to operate. And first and foremost, I think one of the matters that people have emphasized is the fact that the people who appear before us are individuals. No two stories are alike. No two individuals are alike. Their ways of, managing their lives are different. And so we have to be different. When Judge Tucker talks about judicial discretion, that is how we begin to often make a judicial ordered plan for probation and a defendant to go forward, is based upon the information we receive both from probation and often the counsel that are involved. And without that information, we don't know the whole picture. And sometimes when I feel that I need a little bit more of the picture, I have been known to ask questions directly to a defendant with the idea that their attorney can tell them not to answer or to proceed with caution or whatever. And I'm not trying to trap a defendant. I'm trying to obtain additional information that maybe counsel didn't bring out or the defendant did not state in a hearing as to what can benefit that person. Because there's not a soul on this panel that does not want a probationer to be successful, to remain within the community, be a productive member of the community, and operate within the community to make, as Judge Sebestos said, a better community for all of us to live in. And so with that goal in mind, we do begin to try to cater to and not cater, but to create a given program for an individual. Sometimes a wide glove fits a lot of hands, but it doesn't fit all hands the way it needs to. One of the questions was, how much do we rely upon our probation departments and the people who are there working in the trenches day to day? I cannot begin to emphasize enough to those who are watching, and I think my colleagues would agree that we rely upon our officers tremendously because they see people that we don't see. They see them much more often. Usually when we see them, there's a problem. And we're addressing a problem and trying to cope with a problem. But they see them in sometimes at their homes, sometimes at their businesses, sometimes just in the community as a whole, even though they see them regularly on a reporting basis. And so we have to have a good working relationship with our probation departments because we get asked for travel permits. People on probation, they've got family in other places. They have business in other places. Out in this area, many of our probationers travel not only throughout the Permian Basin, but also into southeastern New Mexico to do their jobs. They have to have travel permits to do that. I rely very heavily upon my officers to say, everything's fine, give them the permit, or we're not sure what may be happening, but we need to maybe install a monitor or give a monitor to a defendant so that we know that they are going to perform their jobs in various other counties. And so we can all get caught up in numbers, in generalities, and those are fine. But often we are looking at specific people to where we can tailor a probation or a community supervision, as it were, to make that person successful. Because if restrictions are imposed that aren't there for a purpose, that's improper. If treatment is necessary, let's get it. What we haven't talked about is, or haven't discussed much is, a couple of the alternatives for treatment of the substance abuse felony treatment facilities and the court residential treatment centers. These are a vital part of how we deal with some of the treatment. Here in Midland County, we're very lucky. We have a mental health court, 2 vet courts, a drug court, a transition court, and a DWI court. And so we have the resources to some degree to direct people to where they can get treatment. And treatment is often necessary. And so one of the questions was, are people revoked for technical violations or failure to pay? The system, needs people buying into the system. And part of that buy-in is the fact that they are, paying probation fees. They're paying the cost of their, some of their counseling maybe, or some of their treatment, or a monitor, something that is being used to really assist them in either habilitating or rehabilitating within the system. And, I think the higher courts have ruled long ago that merely because a person does not pay, that they get to go to, in essence, debtor's prison. And so we try to work around that, again, with the individual, with the idea that, they may not have the financial resources to pay. And so that is something we have to deal with as well. Another question was, what about limiting the time of community supervision or probation, say to 2 years? Well, as the other judges have said, it may take a year or two for somebody who has severe problems to adjust to community supervision. They may stub their toe several times. And the idea that it takes us that long in order to begin to, again, adjust a program to an individual. And so I think if something like 2 years was instituted, again, to eliminate judicial discretion somewhat, that would have a negative impact on the entire system. Because at that point in time, I think the reason the legislature has given judges, a great deal of discretion in range of punishments, things of that nature, is so that the punishment can fit the offense, so to speak. And if that discretion is taken away, then the entire system suffers, because at that point in time, I believe you will begin to see the offers coming from the district attorney's office to the various courts, or in some instances, the county attorney's office to county courts at law. I think you're going to see just a request for more jail time, on the theory that some people are not going to be able to receive the treatment they need within a very short period of time. And that's just my opinion. Others may, differ. And, I have addressed some of the questions. I think it is beneficial to the overall panel and our participants that instead of me wandering around the area of probation, that we respond to their specific questions if we can, and give our participants as much insight as we can, specifically to their questions at this time. So I'll turn it back to you, Mr. Patrick.
Thank you, Judge Gillis. I really appreciate it. And thank you for making my job even more entertaining as I have to go through and figure out which of those questions you answered already and which ones I'm going to ask the panel. No, Judge, I'm just messing with you. Thank you again for answering several of those questions. Next up, I would like to introduce Judge Brock Thomas, a district judge out of Harris County, and I think he runs the Harris County Writ Court.
Yes, thank you, Arnold. Thank you for having me. I currently preside over what is referred to as our responsive interventions for change docket, otherwise called our RIC docket here in Harris County, and also preside over 2 of our felony mental health court programs as well. By way of background, had about 27 years in the criminal justice system, former prosecutor, former defense attorney, and about 10 years, a little over 10 years serving as judge of the 338th Criminal District Court here in Harris County before sitting by assignment to preside over the RIC docket here. I thought I'd I was asked to speak a little bit about our RIC docket, what we do here, and the critical role that probation plays in what we do now and certainly going forward in the efforts that we're making here. I'll paint with kind of broad strokes because I know time. Arnold, you'll let me know when I'm out of time, and I certainly want to honor my time and not get in the way of other time and questions for later on. But I do want to spend a little bit of time, since I was asked, talking about our RIC docket. and what we do here. By way of background, I need to set it up by talking a little bit about why we even do what we do with our RIC docket. Our docket is designed, we have 22 district courts, criminal district courts in Harris County. The docket, our RIC docket, is designed as a docket that all of our filings of our less than a gram possession cases, our 1 to 4 gram possession cases, and our felony prostitution cases are all direct filed into this particular docket, as opposed to being distributed as they were before across the 22 district courts that we have here in Harris County. How this came to be, back in 2015, in early 2016, Harris County had applied for a grant through the MacArthur Foundation, through the Safety Justice Challenge, through the MacArthur Foundation. And in efforts to try to address our jail population here, to safely reduce our jail population, the county, the stakeholders were asked to take a look at strategies that could safely and effectively do that. And one of the things that came from that was taking a look at our lower level state jail felony cases and some of our lower level felony cases, specifically the drug cases and nonviolent cases, to see if we could do a better job with how we were processing, how we were addressing those particular cases. In a typical year, we would have about 4,500 to 5,000 of those cases that would be filed in Harris County that would be distributed amongst the 22 district courts. Prior to our creation of this docket, in looking at those, when you back out individuals whose cases were dismissed and individuals that were making a choice of either some type of diversion, be it probation or pretrial intervention, which was not used very frequently back then, or time, probably about 80% of those were taking some form of time, whether it was state jail time or reduction to 1244A in county time. And what we saw was in Harris County, being a large county but with a large number of cases like that, we were actually responsible for about 26% of the state jail commitments during that time because of what was happening with those cases. We had a lot of people in jail, pre-trial, post-trial, taking either state jail time or small amounts of jail time rather than taking diversion. And a lot of those folks just cycling back through the system again and again and again, the rearrest rates being significant. The idea was, what could we do to do a better job with these cases? And so that's what caused all the major stakeholders to come together to see if there was something that we could do to better address this. And out of that came the idea for this responsive intervention for change RIC docket, where we took by direct filing order, those 5,000 or so cases a year, rather than going distributing amongst the 22 felony district courts, to come to one docket to try to give special attention and focus to those cases, not just with detention itself and with diversion opportunities, which I'll speak about in a moment, but also to leverage resource to better be able to address individuals dealing with these kind of cases. So these cases come through one docket that I preside over. But the thing that makes us unique also is that we are certainly not the only entity that utilizes recovery coaches. There are a lot of drug courts, other courts that use those. We actually have, with our Houston Recovery Center, 2 recovery coaches that are embedded with us, that are with us every day, that office right outside the courtroom, that we're able to provide access to participants that come into our court immediately to be able to get recovery coaching, support. The attorneys, we provide counsel immediately, whether it's special counsel that provides for our indigent defendants that are here, or hired counsel. They all know that we have recovery coach access here that we can provide immediately, right here in the courtroom at first appearance if requested, or later on as folks are working their way towards resolution. But we also have individuals with our local mental health authority, with the Harris Center for Mental Health and IDD. We have 2 LPCs that are with us, as well as a peer specialist, peer recovery specialist that's with us, and a social worker. So we're able to link people immediately by having those folks office and embedded with us as well, with referrals to either mental health services for those that have never been connected, or for those that have been disconnected, to help reconnect them with at least mental health services right away. What we are able to do also is we have specialized officers with probation. And again, they play a critical role, obviously, in having developed this program and implementing the program. by having specialized officers that help us here with getting quick assessments. Just like with anybody that's placed on probation across the state, we use the TRAS, their risk needs assessment, to make sure that we get quick assessment for individuals on cases where we're going to have some type of resolution for our different diversion opportunities, to make sure that we're getting folks quickly linked up with the things that they need that address appropriately what got them to the situation that brought them to be in the court dealing with this case to begin with, and what can we get them connected with and help them with, that it can help them navigate this space and hopefully do it in a way that allows them to move forward with their lives and hopefully not come back through the system again, which is beneficial to us and to them. And so what happens in our docket, individuals automatically, if they're charged with a less than a gram or 1 to 4 gram case or prostitution fourth, their cases all come here. The only exceptions are if they pick up one of those cases and they have a corresponding higher level felony already, then they will go to one of the district courts. Some individuals choose not to take the diversion opportunities or choose to stay with us, or if they need a trial or a motion to suppress, in those cases transfer out to one of the 22 district courts, and individuals have the choice of whether they choose to do that or not. But for the individuals that stay with us, for the individuals whose cases just aren't outright dismissed, and we're able to get to that a lot quicker because we have attorneys, both prosecutors and defense attorneys, that are specifically used to dealing with these cases, that if we can quickly get to that, if that's the just result, the better for everyone, the sooner that happens. But when you take out the cases that have transferred out or the cases that have been dismissed, I mentioned earlier that before we did this docket, about this population, about 80% or so were taking time and about 20 were taking diversion. Now we have flipped it over the course of about a 4-year period. When you back out the dismissals and the transfers out, about 15% are taking some type of confinement, be it county time or state jail time, or in some circumstances, even TDC time. But at 85% are taking either a pretrial intervention or a deferred adjudication. By agreement of our district attorney here, almost all individuals that are first offenders with no prior, that don't have any prior felony history, that first felony case, they're being offered a pretrial intervention, which is a 1-year contract. All are submitting to an assessment, and the condition of the contract is that they complete the programming that the assessment recommends, and that there's some give in terms of what the level of programming would be based upon the assessment, but it's an assessment-driven decision. And if the individual successfully completes the contract, then their case is dismissed at the completion of the 1-year contract, and they're eligible to have their case actually expunged, which is of great benefit to us and to the individuals, because obviously having folks not saddled with felony convictions, and not just the liberty issue that's at stake, but the consequences that flow from felony convictions that can follow individuals for a lifetime, it's critically important that we get that right. Our probation department is key in this. They help us to get those assessments done, to get them done quickly, so that individuals, and we have the information on what each individual needs. With our individuals that may not be their first case, that have prior history, in most circumstances, and people can have significant history, they're going to be offered a deferred adjudication if they're not offered a pretrial intervention. The exceptions to being offered that are some folks that have prior violent offenses in their past. That is determined on a case-by-case basis whether they'll be offered a deferred or not. And even on those circumstances where they're not, there may be circumstances where, as the judge, I will do it even if it's not offered, and I'll do it on an open plea. But by and large, most of the individuals that are not offered a pretrial interventions, those with history, whether it's time, prior revocations, prior history, and some have significant histories, they're going to be offered a deferred adjudication. We have seen historically that the individuals that have taken